Hello and welcome to The Print. I'm TCA Sharad Raghavan, Deputy Editor. And now, over the last few days, last 2 days, in fact, the news has, of course, been about the indictments in the US on Gautam Adani and various other people in the Adani group and Azure Power and various other people related to this. But the proceedings being in the US has also raised a lot of questions about, now what happens next? What does this mean? What does it mean for any possible investigation in India? And that's what we're going to explore today. And to do that, we have with you Dr. Irfan Nuruddin, who is a professor of Indian politics at Georgetown University in the US, but he's also an absolute authority on US SEC corruption cases. And he can shed a lot of light on all of this for us. So thank you, Dr. Nuruddin, for joining us.
Thank you for having me.
So now, Dr. Nuruddin, I'm going to start at the very basic. What leads to something like a grand jury indictment, as we saw happen with the Adanis? If it reaches this stage, can we say that they have substantial proof to go ahead with an investigation?
Absolutely. So the US system has impaneled grand juries, which are basically sitting bodies of citizens, right? Citizens of the local community from which the grand jury pool is selected. And what they are meant to be is for more serious crimes, alleged crimes. The prosecutor goes to them, presents the evidence that she has, and asks essentially for an indictment approval. All that means is the grand jury has been convinced that there is enough evidence here to merit a continuing investigation and for this to actually potentially move ahead to trial. A grand jury's recommendation then has to be approved by a sitting judge. But again, the one thing that we should say is that while it is unlikely that a grand jury would approve this, it's unlikely that a judge would approve this, if there wasn't at least prima facie evidence that the prosecutor was able to furnish saying there is evidence of a potential crime, a potential violation of the law, the bar for a grand jury indictment is relatively low. It is definitely lower than a jury trial. The bar over here is, has the prosecution been able to provide enough saying this is not a frivolous case, this is not a frivolous lawsuit? Obviously, once the defense has a chance to weigh in and provide its own version of the story, its own witnesses, a second jury, right, that is actually impaneled to hear the case, might decide that the indicted defendants are in fact innocent of the charges, etc. So it's still innocent until proven guilty. These are just allegations, but you don't get over here if the prosecution was not able to show at least some evidence that convinces a group of individuals and a judge that there is some merit to the case that is being alleged.
Okay, and you touched upon my next question, which is what happens next? What are the next legal steps? Are we talking an arraignment? What about things like extradition or arrest?
So this gets very tricky because of this particular case in which the alleged committers of the crimes that are part of this case, let's call them defendants for lack of a better term, are
Right.
not in the United States. So there can't be an arraignment unless they show up in person and submit themselves voluntarily or are furnished by the Indian government via an extradition treaty. But an arraignment only occurs if they're physically in the United States and can be brought to the court in order to be arraigned. So what will happen in the meantime is two processes, presumably. The first will be a formal extradition request to the government of India. If that has not already been provided, we wouldn't know that quite yet. That's likely to be sensitive and done behind the scenes. But an extradition request asking the Indian government, per the bilateral extradition agreement that the United States and India have, to provide these individuals, to compel them to show up in the United States so that the trial and the proceedings can unfold. The second is, in theory, a provision of some of the evidence and findings from the prosecution's initial case to the defense. So the defense can begin to prepare its own version of the story, right? Know what the evidence that needs to be counted is, and actually decide whether or not it wants to enter potentially plea agreements, whether it wants to just go out for an all-out defense, etc. So the point is that the defense now has to enter the picture. But that relies really on whether Mr. Adani and his colleagues are ready to sort of bring their lawyers into the picture to deal directly with the prosecution. And that's a bit tricky because to do so potentially means that they have to present themselves somewhere to say, hang on, we are actually going to now be defending ourselves. And that will raise a lot of the pressure on, for them to sort of show up in court over here. So just to boil all of that down, most immediate step would be for the US side to request the Indian side to compel the Adani group defendants to present themselves to the competent American authorities so we can begin that conversation. The second is for the Adani side of it to decide how they want to initiate their defense. But regardless, what it means for the Adani side is if they're going to be defending themselves against these charges, they have to present some version of it in court in the United States.
Okay, but then let's assume that none of this happens, that the Indian government does not agree to extradite any of the Adanis, which is the likely scenario, and that the Adanis don't show up in the US to defend themselves, even voluntarily. So what happens then?
At that point, in theory, we can essentially have a trial in absentia, though a criminal trial in absentia would be very unusual. You can't really have an adversarial process of a prosecution and a defense if the defense chooses not to show up. What could be arranged, right, is that you could imagine an agreement being reached between the defense and the prosecution that basically says, listen, we will allow our lawyers to come and represent us, right? And if we are found guilty, etc., then we can negotiate essentially whether or not we show up for prison sentence if that's what is decided by a jury, etc. But it is unlikely that the US government would agree to that. So in that sense, there's a little limbo of maybe of an extended period. Maybe it basically hamstrings the criminal side of the case. The civil side of the case, on the other hand, could definitely happen with an issuance of the law of the judge basically saying that he's going to hold the defendants in contempt for defying the order of the court of a legal authority to say you have to present yourself over here. And essentially then the defense would not have a chance to offer a counter argument and potentially makes itself very vulnerable to pretty hefty fines that could be quite crippling for normal companies. Again, the Adani Group is not a normal company in terms of the resources it commands, but the fines that we could be talking about here could be quite astronomical for normal purposes because of the scale of the offenses alleged.
Right. So I was actually going to come, you again touched on two of the things. One is that, so arrest is very much on the cards if the criminal proceedings go through.
Absolutely so. So there are two sets of charges at the core of the indictment that has been unsealed over the last couple of days. The first are criminal charges stemming from the alleged violation of the Foreign Corrupt Practices Act, or FCPA. This is a 1970s era law that is still in place that makes it illegal for American companies to indulge in violations of American law, even if they're doing so anywhere else in the world. So in theory, for your listeners, what that means is that even if, in theory, paying a bribe, right, which is the alleged offense over here, is legal in the country where the bribe was allegedly paid, because bribery is illegal in the United States, an American company found guilty of engaging in such behavior in a third country is still liable for prosecution under FCPA.
Right.
And the origin of this was the idea that if some companies are willing to pay bribes and other American companies choose not to, it puts the companies that are willing to pay bribes at a competitive advantage over the ones following American law. So that was the original origin story. That's a criminal offense. And so that's punishable with up to 5 years in prison. Beyond that, there are allegations that there were violations of the Security and Exchange Commissions for committing fraud under that. That's punishable by crime, by jail sentences of up to 20 years. So we are talking about pretty serious potential jail sentences. Now, these are white-collar crimes. These are the FCPA is largely used to prosecute executives. I don't have the full case history, but it's very unusual that anyone, even if found guilty on all charges, would ever be in jail for 5 years, 10 years, etc. Right? I mean, so my guess is most of those cases get pled down. But what we do have then is the potential financial side of it. So the financial side of this stems from an SEC, the Security and Exchanges Commission. The equivalent for our Indian listeners is the SEBI sort of thing. And that argument is that even after, it boils down to that, even after the Adani Group was informed in March of 2023 that they were under investigation for an alleged FCPA offense, they continued to raise funds through investors by issuing bonds in the United States through their US incorporated entity to raise funds from American investors without divulging that they were under investigation for an FCPA violation. So in fact, the statements put out by the Adani Group said, we are not aware of any such adverse proceedings. We are fully in compliance with all the laws. We have gold standard regulatory and anti-bribery internal controls. And what the US indictment says is that, hang on, we had told you that you were under investigation for an alleged offense, and you never disclosed this to your investors, thereby potentially defrauding them because you were not transparent. So there's a bit of a chicken and egg over here, just to complete the thought, which is that if they are in fact, in theory, if this were to go to trial and were proven to be innocent of all the charges on the bribery, in some sense, the SEC violations that have been alleged also kind of go away, right? If you never committed fraud in the first place, you're not guilty of having not told people. You might have a smaller fine, which that you should have told people that you were at least under investigation. They should have had that information. But then we're talking about a pretty small thing. But if not, if the FCPA violation can be demonstrated in court, and we're looking at potentially a pretty significant economic fine, if nothing else.
Yeah, so about the fine, now the allegation is that the bribe amount was about $265 million, the planned bribe. So does the fine, is that correlated to the bribe amount, or can it be several multiples of that?
Several multiples are entirely possible, and in fact probably likely, right? So you've got two different dimensions over here. One is that the scale of the bribery is huge. I mean, just to give a parallel, there is right now in federal court in the same district that is actually being prosecuted by the Southern District of New York, but the same broad jurisdiction, an FCPA case going to trial in March that has been ongoing for 3 or 4 years now, stemming from a bribe allegedly paid by an American company in India about 10 years ago. The sum total of that alleged bribe was $2 million, right? And we're looking at executives being prosecuted and threatened with jail time over that. This is not $2 million, this is $250 million, right? So it's a much larger scale, which suggests that it was also involving much higher level officials, if the reports are to be believed, and that the nature of the quid pro quo was much more significant. So I suspect that if this were to meet a jury and finally the prosecution was successful, that what we'd be looking at is several multiples of that, both for what would be assessed as sort of damages, but really for the punitive and demonstration effect of saying this is not behavior that can be tolerated. And then we get not just to the bribery part, but again, remember that the core of that side of it is that there were American investors who in good faith chose to participate by providing capital, who have been defrauded. The value of those investments have gone down. Those people need recompense. So what we could see is also ancillary sort of compensation for investors to be made whole and maybe compensated for what has happened to their investments, etc. So I think this could be really significant. We could be talking upwards of $1 billion before all's told. Now, just to anticipate, obviously, once again, we have a situation where the defendants are not in America, are unlikely to show their face over here voluntarily, and definitely, I think, unlikely to be put on a plane forcibly by the Indian authorities to come face a trial over here.
Right.
But you do have assets the individuals and of the company at the core of the allegations in the United States. And so you could have criminal forfeiture of that, where the US government seizes those and liquidates those as a way of making it whole. I think the big picture from an Indian economy perspective, of course, is that to the extent that the Adani Group had pretty ambitious plans for expansion of its solar projects and other projects in the United States, at least for the medium term, if not the long term, those are basically done. It's just hard to see how the Adani Group maintains any footprint in the United States until these allegations are addressed and resolved to their satisfaction.
And now, what kind of time frame also are we talking about here? Is this likely to be a quick process, or do you think it'll drag out?
It will drag out. It won't drag out the way Indian court versions of this are. So but it will drag out. This is one in which both for due process. I mean, where we are right now is that the alleged defendants were notified in March 23 that an investigation was ongoing. They would typically have been furnished with a version of the indictment, at least through their lawyers, before it was completely unsealed and made public, right? Especially given the sensitivity. No one on the US side of it is naive about who the key defendant is over here and his relationship to the Prime Minister and to the Indian government. But now the defense has to basically decide how it wants to handle things. At this point, they've said the charges are baseless, but all accounts are that Mr. Adani and company have not been reachable. But just for due process, what it means is the defense could have, under U.S. law, the right to demand a speedy trial, right? So U.S. law allows for speedy trials as a matter of human rights. You can't just have under trials, indefinitely in the way that unfortunately has become common in India. So the defense could demand a trial within 70 days. But the defense is unlikely to want to do that. It's likely to want to let this drag out as long as it can, especially if it thinks that it needs to really put together a pretty solid defense. And so the pacing of this is going to be likely measured in years. It would be very unlikely that anything happened, even if the defense is willing to cooperate with the proceedings before the middle of 2026, if not actually later than that.
Right. And so, okay, now in a nutshell, what you're saying is that several things are on the cards. Extradition is entirely possible, but not likely. Arrest is also possible. A fine, a very hefty fine, and penalties and compensation, all of that is also possible. And a seizure of their assets in the US is also possible.
All of that is right. Let's add one more wrinkle to the story. So one way that the Indian government, and this is where, of course, politics enters the question, the allegation at the core of this is that the Adani defendants, to use it as a blanket term, though it's not just all Adani Group, there are also these members, 4 of the people named in the indictment were working for a Canadian investment advisory firm that chose on behalf of that of a client to recommend investing in the Adani group. Right. In fact, that's a major investor. So there's a third country also involved, that's Canada, that might on its own choose to begin its own proceedings. But the core allegation is that this bribery scheme involved Indian state officials, which, if true, is a violation also of Indian law. So the one possibility is that the Indian government, right, whether in good faith or not is for someone else to decide, but the Indian government could say, we are not extraditing, not because we don't want to cooperate, but because the alleged crime is a violation of Indian law, and we want to keep our options open to investigate and prosecute such said violation within the Indian court system, right? So it's not that we're not cooperating with sending him to New Jersey or to New York. We want to follow the evidence all the way, because if this actually occurred, he should be prosecuted here in India, and we get first dibs, if you would, on that. Again, whether that's a good faith or a bad faith claim just to delay it is, for other people to comment on. But it's not as simple as simply saying, send him back. So just as a hypothetical contrast, a lot of times where these extradition treaties are normally used is, let's say, an Indian citizen living in the United States commits a crime, commits a murder, commits a robbery, right? Just a more, say, typical kind of crime, and then realizing that he's in trouble, or that he's committed this crime, gets on a plane and flies back to India, right? The alleged crime was committed entirely within the United States, but this person has absconded to India. That's the kind of situation in which the Indian government would quite happily potentially put this guy in handcuffs and put him on a plane and send him back over here. India is not implicated in terms of where the crime was committed. There are no sort of spillover effects, no repercussions on the India side. It's entirely on the US side. That's largely where these extradition treaties are typically used and implemented. And India and the United States cooperate quite extensively in that regard over there. What we have over here is something very, very different. And even though it sounds like a cliche, it is pretty much unprecedented to have someone of the scale and scope of Gautam Adani at the center of an indictment involving extradition, where the scale of the alleged violation is as large as it is, and where it involves, per the evidence that the prosecution claims it has, direct connections to bribe-paying two major Indian state officials. So there's a lot of complexity over here. And I think what it means is that there is no scenario, I could say this quite confidently, where any of this gets resolved in the next 2, 3, maybe even 4 years. The bad news from the Adani Group's perspective is that it leads to a constant drip of bad news and speculation about what's going to happen, a sort of cloud of suspicion that will last several years, right? It's not just going to be able to be resolved quickly. It comes on the heels of 2 years ago, the Hindenburg Group's sort of allegations of fraud in the financial accounting of the Adani Group. And what we're going to see, and we're already beginning to see, is a lot of parallel investigations that will pop up in other countries as they begin to look at this. And again, we don't know whether those are in good faith or whether it's something else, but we've seen in Kenya, they've already canceled Adani contracts. Right. There are other countries that are saying they're going to re-examine those contracts. So in India, the scale of the operations might be unaffected, but globally, this is a serious blow for the company.
But that is from the business perspective, the Adani's global operations and how they might be impacted. But you also mentioned that the Canadian authorities might launch a proper investigation of their own, because the Canadian pension fund is involved or is allegedly involved. And similarly, the Adani Group companies, several of them are listed on various stock exchanges across the world. So all of them might also be now keen to see if the money being raised over there has been used in some sort of illegal activity over here.
Right, and not just whether the money directly, but because of the SEC indictment is not just that the money raised here went there. Money is fungible, so we don't know whether these dollars are the ones that went. It is whether the disclosure requirements on these various exchanges requires that a company disclose potential adverse legal proceedings in other countries to potential investors. So again, I'm not an expert on that stuff, but let's imagine that the UK authorities say, hey, you, since March of 2023, have raised X pounds using our bourses or our investments, and our laws say that you were supposed to have let these potential investors know that proceedings had been begun in America over here, right? And that it was pending investigation, etc. But you were supposed to have told them that. You didn't tell them that. That is equivalent to the fraud allegation that's at the core of the SEC claim over here. Right. So you could see that kind of knock-on effect of other places that the Adani Group has a significant capital presence, right? And not just where they're doing work, but actually where they're raising money to fund a lot of that work. Say, you should have disclosed more than you did. You were in fact acting in bad faith. There are going to be penalties over here, maybe not criminal penalties, but there might be civil penalties. And then definitely, I think any place where there are major contracts for major infrastructure projects now is likely to at least appear to investigate whether there was any impropriety being done, right? If only to sort of satisfy potential watchdogs saying, if they're doing it in India, how do we know that they're not doing it over here? So Dhaka has already said that it's likely to look at the energy contracts that the Adani Group has signed to supply electricity to Dhaka, right? Sri Lanka obviously has a lot of pressure that will be exerted by China to re-examine the port agreements and other things. We've seen what's happened, of course, in Kenya. Tanzania says that it's going to be looking at some of its contracts again. The end result of a lot of those investigations might be business as usual. They might say, we are satisfied that nothing untoward has happened over here, but there could be some complications. I do think Canada is a much more serious concern. It's politically very sensitive. If, in fact, a pension fund, right? This is a vulnerable group. These are older people whose livelihoods and retirements are vested in the pension fund. So the pension fund decides that it wants to start its own case and say, listen, we were defrauded, right? And in fact, take the Adani Group to court in Canada. It doesn't require that the Canadian government get involved in the way that the US DOJ is involved. It could actually just be a class action suit on behalf of the pensioners saying that we were defrauded. So a lot of speculation over there, to be honest, but this is only the start of the story, I suspect.
Right. And now, from the past experience of various other SEC corruption cases, have other countries launched their own investigations on the basis of what the SEC has found? For example, let's say, is it possible for India to do the same?
It is. I mean, so there's a lot. There could be information sharing, right? I mean, so we have various sort of rules that govern sort of what information can be shared. But look, the core of it over here is there are two things that this dovetails with that allow for some of that copycat kind of investigations to get launched, right? The first is that we're talking about a group that has a global footprint. And so a lot of times the SEC violations or the FCPA violations that are prosecuted don't involve a company that has got such a global footprint, right? There's a company trying to get a contract to build a bridge. It's based in New Jersey. It's trying to build a bridge in some country. Some bribe was paid. It's typically a low-level official that was bribed, and so there's something like that. And so the notion that what we have over here is a global conglomerate, right, aspiring conglomerate at a global level that potentially involves lots of countries, that's pretty unusual for FCPA. Most of these tend to be much smaller in terms of the scale of the operations. The second is you have countries on the other end that almost always in these situations are countries that have relatively weak rule of law, which is why they are environments in which bribes are commonplace and maybe sort of part of the nature of doing business. Bluntly, a lot of those countries are uninterested in opening up Pandora's box of looking at whether there's bribery being paid within their own system, right? I mean, so again, we don't know whether a bribe was paid. We have no idea at this point what the identity of the other side is. The Andhra government has said that they don't think that they were, that they don't think there's anything over here, etc. So there'll be a lot of denial, but without sort of prejudging any of it, what an India investigation would require is for the Indian authorities to decide that the cost of, beyond the fact that it's Mr. Adani, that the cost of uncovering potentially large-scale corruption in the state officials is worth the political fallout that might occur. We have no idea. Let's assume it happened. $250 million. That's a lot of money. How did that money get passed through? Where is it sitting right now? Who else got a cut off it, right? How deep does that entire thing go? Who else had knowledge, even if they weren't directly beneficiaries? It's just very hard, without being overly cynical, it's just very hard to imagine that the Indian authorities take this very seriously. So what I think is more likely to occur is really for other countries, not India, not the United States, other countries, to essentially look at this more from the civil side of things, and particularly from the investment side of things, and essentially say, were tenders or for selling bonds, raising, if they're listed over here, the stocks, did they meet the disclosure rules that we require, that if you're under prosecution or investigation elsewhere, you have to disclose it. If the rules require that and the Adani Group did not, then they're vulnerable to something. And then I think you'd have those authorities reach out to the United States and say, we are considering this. Would you be willing to share this particular piece of information to help us with our investigation? It will be up to the US government whether or not to do that. But there are no rules inherently prohibiting such information sharing within scope, and it's not privileged as such.
Right. And now there's also a possibility that all of these countries, including the US, there is a possibility of banning the Adani Group companies from raising funds over there?
Yeah, so the Adani Group has already cancelled a planned 600 million bond issuance over here that was supposed to hit any day, which is probably partly what explains the timing of the unsealing, is to not allow that thing to go ahead. But we want to be careful about sort of sequencing over here, right? It's an indictment. These are allegations, innocent until proven guilty. In theory, the Adani Group could continue to act as business as usual until the trial is entirely complete. What you could have, if they were to do that, is for the SEC to say, hang on, we're going to sort of be pretty intrusive because they're under investigation, and really open up your books before we allow you to do this in a way that would just sink the bond issuance in the first place, right? I mean, so they don't have to do it through anything other than, if you just shine a broad of light, which investor in his right mind is going to be giving you money? And so it's a bit of a moot point. Once this hits trial, or once some sort of resolution is reached, assuming that the prosecution can achieve its goals, at that point you're done, right? I mean, I think there's no way that you can raise money over here, either formally or informally. And I think the larger question is, and again, lots of speculation, Sharad, just want to be transparent with your listeners and viewers, but if this goes all the way to trial and a prosecution is reached, but Mr. Adani and his co-defendants don't come here to, allow themselves to be put in jail, for instance, then larger questions are, how willing will the US government be to actually follow through on potential seizure of property, right? What happens to the company that is incorporated in the United States? Are they going to be said that you cannot fold up, you cannot sell, because those are assets that are potentially now under threat of seizure? So you can't liquidate it because we want to be able to claim it if it isn't liquidated. So a lot of that is yet to be understood as we basically get more information that comes out. I think from the Indian government, just one dimension that I just want to put on the table for us to all be thinking about. I think the Indian government is in a tricky situation. On the one hand, it would be entirely within their rights to say, listen, this is an alleged crime that occurred on our soil. We reserve the right to investigate this fully. But to say that and not launch a serious investigation, especially when you have the opposition parties going to just be seizing on this and talking actively about it, puts them in a difficult spot. But you also have the question of, what role does India want to be seen in terms of a global citizen, in terms of the sharing of information and the enforcement of global laws? Because this comes a year after another indictment was unsealed, and that is the alleged murder for hire allegations, which now the Canadian authorities are saying, went all the way to the very top of the Indian political establishment. So this is not just, I don't think it makes sense to view this completely in isolation in terms of the ramifications. I want to be clear. I don't think that this is malicious. I don't think that we'd get here as some sort of quid pro quo. This is not the US government trying to, find goodness, if you would, and take action on this dimension because they didn't get what they wanted on the murder for hire kind of thing. But you stack these things together and you essentially have India getting potentially slightly more isolated, a slightly better rap about, you are not cooperating. You keep talking about wanting to be one of our partners and a global leader. You're not playing by those rules. And so I think there's obviously, this is where the diplomats have to go really to work to preserve India's broader ambitions and reputation, even while walking a very delicate path in terms of the current case.
Right. And okay, now my final question has to do with your new president coming in January. and what potential impact he could have on this investigation, because he gets to appoint new judges.
Yes. So in this case, the key appointment power is not the judge in question, though of course he does get to appoint new judges. It is that he gets to appoint the new U.S. attorney for the Eastern District of New York. And so the U.S. attorney in charge of the case, whose name is on the indictment, is a Biden appointee. After January 20th, that person will no longer be in position, and until the next U.S. attorney is appointed, which should typically happen pretty quickly, those tend to not be very controversial appointees, will be. That person has been, the person named to be the most likely successor is an individual named Jack Clayton. Now, both Mr. Trump and Mr. Clayton have in the past commented that they think FCPA is not a good law, that it puts American companies at a significant disadvantage going out. So you're trying to compete for a contract elsewhere. Other companies, Chinese companies, Indian companies, Brazilian companies are happily paying bribes, and the US company is hamstrung because they can't pay a bribe because they're afraid of the FCPA prosecution. So lots of American companies raise the same question, that they feel often that they have to sort of, compete internationally with one hand tied behind their back. And Trump and Clayton have expressed sympathy for that position. The truth is that the Adani company is being under FCPA, but it's not your classic American company. This is not the equivalent of, Apple or a Jeep or Chrysler being prosecuted elsewhere. This is a company that everyone understands is an Indian company. It has an American entity, but it's not I don't know that Trump sees this as America first, right?
Right.
I do think also then you have this other question of Trump is famously transactional. I think he does have a idea that he and Mr. Modi have a particular relationship that he thinks can be used to his advantage. And so I think what you could have is the case continuing, but maybe some foot taken off the gas, right? And essentially saying, we don't have to push this too aggressively. We might be more open to sort of really exploring plea deals with the defendants, right? That we don't let them get away scot-free, but we take the jail part of it really off the table and say, you guys can afford to pay a pretty incredible fine and do it, close up shop, go away, and we let all of this go away. So lots of scenarios over here, but it would be, what I think is least likely is for a subsequent U.S. attorney to simply say, I'm just going to walk away from here, to disregard the recommendation of the grand jury, etc. It's not that they couldn't do it. I think it would be unusual, because I suspect that the current U.S. attorney, knowing fully well that he's going to be out of that position in 2 months, has prepared the dossier to be as airtight and as convincing to make it hard for his successor to walk away on what has now been, a year and a half's worth of work. And I think, again, that's probably worth just reminding everybody, even though you and I found out about all of this 2 days ago, right. The Adani defendants were informed of this in March of 2023, which presumably tells us that the investigation into this alleged offense started well before that, because the US government and authorities would not have taken the step of letting them know that until they were satisfied that there was something over here. So really, we're talking about a timeline, and lawyers and attorneys in the office potentially working on this as early as 2022. So you got 2 years worth of work. Mm-hmm. Whoever comes next is going to have to take the time to go through all of that before they decide what to go, which also adds to why this is likely to take a while before anything new happens. But I think one way or other, this keeps moving forward. But definitely the new president and the new new U.S. attorney for that district will have a lot of influence over just how aggressively it's pursued, and on what sort of side deals or what sort of alternative deals they're willing to contemplate, either with the Indian government or with the defendants in question.
All right. But thank you so much, Dr. Nuruddin. This has been very, very enlightening, and I'm sure all of our viewers also learned a lot from it. But thank you so much for your time.
You're very welcome. Thank you for having me, and best luck.